Well, hi again, everyone. It's Rob Ryder, and it's Saturday, July 5th, 2025. And today, protest Esquire identity. Well, that sounds like a worthy cause. In this particular case, the Court of Appeals for Veterans Claims in case 254231. But really, what I'm going to talk about, you could do in most any court. Whether they accept it or not is, that's yet to be determined. But this is where I am in that particular case, which was really the subject of my last video, which you'd find on Rob Ryder, R-O-B-B-B, 3Bs, Rob Ryder on YouTube, Court of Crimes for Veterans Claims. And in this case, I'm trying to get a specific identification card that's in Title 38 issued to me, and I'm asking the court to give me extraordinary relief to get the secretary to issue it because I've tried different ways to get it, I haven't got it yet. So as it turns out, the secretary never wrote any rules on how to implement that particular section of Title 38, which Title 38 gives him the authority to do, that he can write any rules required to implement Title 38 in the United States Code. Well, I don't know if other sections have been done by the secretary, but this particular one hadn't been, so I said that's reason enough to take it to the court to see if they'll issue the petition. If they'll issue an order based on that petition. So that's where that is, and we'll see where it all ends up. So give me just a second here. So just a really quick blow, so we see where we are, right? This is the general docket for the United States Court of Appeals for Veterans Claims, case 254231. And that's where I put my petition in, and they put a notice in that I put a petition in, and then I put another addition to my petition in. Then I paid the filing fee, and then that's what got them to assign a judge. And basically, nothing happened then from that date, which was the end of May, to 6/24, when I got an order that said, well, they're going to deny my petition. I said, well, that sucks. So I didn't know what to do exactly, but what I did first was I filed a grievance for misconduct against the judge because, as we'll see, the order he issued doesn't have a seal on it. There's no court seal on that, so I don't believe it's an order of the court. And a couple other extraneous things, but that was my idea then. But then I got the idea, well, I'm going to put in a motion for reconsideration. I read the rules. I said I could. If I don't like the answer I got from a single judge, I can ask for reconsideration, and so I did. Well, all of a sudden, I put that in on the 30th, and must have been over the weekend then. On the 2nd, up pops an appearance by, is that Giles or Gillis, or I don't know how you say it, Gilles, right? That says he's appearing for Douglas A. Collins, who's apparently now the Secretary of Veterans Affairs, although that's not his full legal name. There is nobody with an A in their name, so, or an initial. In fact, his name is Douglas Allen Collins. It's easy enough to look up. Just go look up on Google. I'll tell you what his name is. So then, after they put that in, I said, well, I don't like that. I'm going to protest the appearance of Giles as the representative for the Secretary of Veterans Affairs, Veterans Affairs, because according to the rules, the representative of the Secretary of Veterans Affairs is the General Counsel of the Department of Veterans Affairs, which is a particular person, right? A particular Esquire is the General Counsel. There may be an office of General Counsel where all his peeps work, but there is somebody who is. And I said, that's who's supposed to be there. And so I was going to just object. I asked Grok, well, what's something stronger than an objection? And Grok said a protest. And sure enough, you go look up protest, it says to make a solemn declaration expressive of opposition with, against, as he protests against your votes, right? So it's a protest. To affirm a solemnity, to make a solemn declaration. So, does that mean you have to swear to it? I don't know. Anyways, I put it in. And that's kind of where we are now. So what I wanted to do, what this video is for me, is I want to make a public record of all the stuff that's happened, and read the guy's order and what I put in, and cover these different points as I go along. And so if you're into this kind of stuff, you might want to follow along, because, everything I'm going to show you is exactly true. Whether I can get them to do anything with it or not is yet to be seen. But as we all know, our deal with Esquires, they lie, cheat, and steal. It's part of their job description. So where am I now? Give me just a second here and we'll get started. I guess I want to make sure I point out two things before I forget, right? That what I'm doing here in this Veterans Court is the same as filing a miscellaneous case in a district court. Right? You can file, as a veteran, I can file a case for a petition for extraordinary relief, where I'm asking for them to do something that the government's supposed to have done for me, right? So I'm petitioning a grievance against the government. And if it's in their jurisdiction, well, then they can do it. Well, so can the district court. And the district court has this thing called the miscellaneous case docket, where I think it's $52. You can file a case, miscellaneous case there. And what's one of the reasons you file a miscellaneous case, according to the description, is because there is no other case open for the situation you're talking about. So I don't want to go open up a civil case. I just want to get them to make somebody do what they're supposed to do. It's more like an administrative thing. And we can see these district courts have all sorts of power, or federal courts have all sorts of power. They can even stop the president. At least that's what they believe, until the Secretary or the Supreme Court does something about it. But how they do that is because all these federal courts have this thing called all writs jurisdiction. And they can write all writs under the All Writs Act, right? So they could write a writ to give you whatever relief you need. And in my case, the relief I need is I need to get this veteran's ID card. Every veteran needs to get this veteran's ID card, because what it does is it serves as proof that such veteran served in the armed forces and has a Department of Defense DD-214 or other official document, official military personnel file, the veteran that describes service to veteran. That's why, right? Because this is coming, you're getting the card from the VA, but it has to do with your service in the DOD. This has a tie between your DOD records and the VA records. And if you're in the VA, or you deal with the VA, you have to know, if you start looking at the mail they send you, that you get mail in all sorts of different styles to your name, but you only ever sign a contract in one style of name, and at least for enlistees, it's last name, comma, first name. Right? So they should never be using the name of the middle initial to identify me, yet they always do. Or they don't use, sometimes they put Rutluski, comma, Robert A. Sometimes it's Robert A. Rutluski. Sometimes it's Robert Rutluski. Sometimes it's Mr. Rutluski. On occasion, it's Robert Allen Rutluski. Or it could be Rutluski, comma, Robert Allen, which is the only one they should be using. Well, because they're using all these different styles of names, they have all these subsets of records that all pertain to you, but they're not all under the same name. And your name is supposed to have been protected under the Privacy Act. So there you go, right? So I want everybody to agree that my name, when it comes to the VA and the DOD, is Rutluski, comma, Robert Allen, just like it is on my enlistment contract, just like it is on my DD-214. And to do that, I have to pay for a card. The Secretary shall charge a fee. There is no may. He shall charge a fee to each veteran who receives an identification card issued under this section, including a replacement identification card. Ain't happened yet. And anyways, the card that they're talking about, so when you read, you read between the lines, this card used to be, so on the day before the day of the enactment of this act, July 20, 2015, veteran identification cards were issued to veterans who have either completed the statutory time and service requirement for retirement from the armed forces, or who have received a medical-related discharge from the armed forces. It's a frickin' armed forces card. It's going to be a DOD ID card, which I know they give to people who are 100% disabled. They get a DOD card. It's not the same one that you got as a active duty, but they have one. Well, here's another one. So we're really not even talking about a card for the VA. The VA is just the go-between to get you the card, because they share your identity information with DOD, which is used by DEERS to decide which card you get. DEERS is an acronym for whatever the hell it stands for. It has to do with you being eligible for an ID card. So anyways, that's why I filed the petition. And eventually, like I said, I got an order, which is right here from Toth, Judge, where he said that on May 27, 2025, Robert Rudlewski filed a petition for extraordinary relief that asked the court to order the Secretary to issue him a veteran's identification card as authorized by 38 U.S.C. 5706 and to collect the corresponding fee. Hell, I should have just read this and let him explain it to you. This is what's happening. He says that he attempted to obtain the card in October 2024 by filing a lay witness statement with the VA that was forwarded to his Veteran Service Organization representative, who then submitted the same evidence to the VA. I gave it to the VA sent it to, the Disabled American Veterans Association, who then they just really took what I already gave them and sent it back to the VA, so none of that did anything, in other words. My representative didn't get me a card. Okay, when he did not receive his card, he filed a complaint with the VA Office Inspector General Hotline. I did in February 2025, but says the OIG has taken no action on his complaint. He contends that because the VA has not promulgated any regulations to implement the statute, he has no other means to seek relief. Petition at 2.4. Not really sure what that was. He also asserts the VA usage of variations of his name, like Robert A. Rutluski, Robert Allen Rutluski, make him insecure, and his purse, his papers, and effects in violation of the Constitution. I have a constitutional complaint. I'm insecure because I got all these different records. That some of my papers got Robert Allen Rutluski, some got Robert A. Rutluski, and it's affecting my entitlements. Same with any other veteran. We're all being affected by this hiding of your identity that they do. So, under the All Writs Act, the court may compel action of the Secretary unlawfully withheld or unreasonably delayed, like, not giving me an ID card. The drastic remedy of mandamus cannot be used as a substitute for standard VA appeals process and will only be granted when the court is firmly convinced that it is warranted. 3 conditions must be met for court to issue a writ. Petitioner must demonstrate lack of adequate alternative means to obtain the desired relief. Petitioner must demonstrate clear and indisputable right to the relief or to the writ, and the court must be convinced under the circumstances that issuance of the writ is warranted. Sounds like a pretty low bar to meet. But in this case, Mr. Rutluski, right, before I was Robert Rutluski, now I'm Mr. Rutluski, has not demonstrated he lacks alternative means to obtain his desired relief. While he has taken some steps to acquire his veteran's ID card, he does not allege that he has followed up with either his VSO, VA, or OIG, and that those additional efforts have been unsuccessful. And as for his concerns about various formulations of name used by the Veterans Affairs, the VA, he has presented no evidence that he sought to remedy the matter with the agency and been refused. The court recognized Mr. Rutluski's assertion the VA has not promulgated any regulations pertaining to the process by which a veteran could obtain an ID card pursuant to Section 5706, but this court is not the appropriate forum for raising such an issue. Well, who is? A veteran can instead petition the agency itself for rulemaking. Well, la-di-da, la-di-da. Thus, the court is not convinced that issuance of a writ is warranted in this case. However, the court takes judicial notice that VA webpage how to apply for veteran ID card, which states that as of September 2022, all new veteran ID cards are digital. It provides information instructions regarding applying for a digital ID online. Tells you how to do it. Noting that VA web pages are something the court can take judicial notice of. Mr. Rytlewski might direct his attention to this web page. VA webpage informs that a veteran can obtain an ID card by accessing the website listed above and creating a verified account. The website also says that to obtain the ID card, the veteran must provide several items, including Social Security number, scanned copy of ID, DD-214 or other discharge document, copy of current valid driver's license, passport, digital photo, but nothing about a fee. Mr. Rytlewski may consult VA webpage for an official list of the procedure. Finally, according to the website, a person seeking assistance in obtaining the ID card can contact vetidcardva.gov. Accordingly, it's ordered, Mr. Rytlewski's petition is denied. All right, by Joseph L. Toth, which is not his full legal name. And there's no court seal on it. So I don't believe that the judge actually did this. I think the administrative state did it. I say that this is an auto pen signature. I don't care that it's in blue ink, it's still auto pen. Right? So these are the things I wanted to complain about. So that's what I did. And I said, okay, well, I'm not going to just accept, no, you can't. Let me go do a little more research. And I did. And now I'll show you what I came up with to banter back to them. Okay, so that was ordered, right? This is the work of an Esquire wearing a black robe going by the name Toth. Which technically, your surname is your legal name. So I should, that is his legal name. Just Toth. That is his legal name. According to the Real ID Act, your full legal name is either your first name, last name, first name, middle names, last name, no initials, no nicknames, or your surname. And it didn't say that your first name, middle name, last name had to be in any particular order. They just all have to be there. The point is you can't use any initials. You can't use any nicknames. So just using your surname, Rytlewski, by itself could be considered your legal name. So now it really matters what do they put before you. And they want to say you're a Mr. In my case, like Mr. Rytlewski. Well, I'd done videos in the past, having done the research, that a Mr. was like a stable hand way back in the day. He was far under an Esquire, right? Where an Esquire was the shield bearer of the knight. So he didn't have a title of nobility, but he worked as the right-hand man of the guy who had the title of nobility. Where the Mr. was a guy that worked in the stables. Don't let them call you Mr. That's all part of this. Okay, so what am I going to do? I'm going to put a motion, a petitioner for reconsideration, and then the alternative by panel. Okay. Okay, so I went to the rules of practice and procedure of the court. And I was looking through here, and I saw, where did I see it? Oh, motions for reconsideration, panel decision, full court review. Let's look at that. Motion for reconsideration. It says, if a clerk, no, not that one, a party in a case decided by a single judge may move A, for reconsideration by a single judge, B, for panel decision, or in a single motion for reconsideration by a single judge or panel in the event the single judge denies reconsideration. That's what I decided to do, right? So just following the rules. All right, motion for reconsideration by a single judge or panel decision in the event the single judge denies reconsideration. Well, that'd be called copy and paste from the rule and make that the title of your motion and move on. So Rytlewski Robert Allen, the petitioner in case 254231, before Toth, judge, requests reconsideration of the single judge order that denies petitioner extraordinary relief due to its legal and factual errors as listed below. So Toth Judge order claims that on May 27, 2025, Robert Ritluski filed a petition for extraordinary relief. Oh, this is an intentional falsehood or mistake. Ritluski, Robert Allen, is the petitioner's name. Robert Allen is the petitioner's first name. Robert Ritluski is a John Doe legal fiction and certainly not a party to the enlistment contract that resulted in petitioner becoming a veteran soldier for life. Number 2, Toth Judge order claims the drastic remedy of mandamus cannot be used. Petitioner did not specify what writ or writs to use, and instead expects the court to issue all writs necessary to enforce 38 U.S.C. 5706, the same being a supreme law of the land under Article 6 of the Constitution of the United States. Not doing so is unconstitutional. Right? This is a supreme law of the land. Once it became part of Title 38, which is called positive law, well, under Article 6 of the Constitution, right, it tells you things that are the supreme law of the land. It says the Constitution, treaties, and laws of the United States. Well, here's one right here. Okay, so Toth Judge order, this is number 3, under All Writs Act, the court may compel action of the Secretary unlawfully withheld and unreasonably delayed, which is really all I'm trying to get them to do, right? I mean, he's putting my he put my argument into his answer. 38 U.S.C. 5706 has been the supreme law of the land since July 20, 2015, and constitutionally obligates the Secretary of Veterans Affairs to collect a fee and issue Veterans Identification Card from that very day. The Secretary and agent's failure to comply with 38 U.S.C. 5706 is a fraud against the United States in offense of Title 10 United States Code and Uniform Code of Military Justice, or it's an administrative oversight that can be easily corrected by court-provided extraordinary relief. So there, just just do what you said you could do. Compel action of the Secretary unlawfully withheld and unreasonably delayed. Okay, then Toth Judge claims 3 conditions must be met before the court can issue a writ. The petitioner must demonstrate a lack of adequate alternative means to obtain desired relief. The petitioner must demonstrate clear and undisputable right to the writ, and the court must be convinced under the circumstances the issuance of the writ is warranted. Well, this all sounds reasonable. So Title 38, 5706 makes it the Secretary's duty to issue the card upon request. But the petitioner has no means of communicating directly with the Secretary. Petitioner has already provided evidence that the Secretary's agents will not administer the law. Notice to agent is notice to principal, and the Secretary has been repeatedly noticed by petitioner's interactions with the Secretary's agents. Toth Judge demands that the petitioner must demonstrate a clear and indisputable right to the writ, even though, as part of the petition, he has a copy of the very document 38 U.S.C. 5706 requires from a veteran. In other words, I got my DD Form 214. Toth Judge can apply to the Secretary for Service Members Civil Relief Act Certificate of Service. Finally, I meant to add more to that. Something happened. That's really not a complete sentence. I'm not happy with myself. I'm going to go right past it. Finally, Toth Judge clearly states that the court must be convinced. But what Toth Judge failed to mention is that a single judge is not the court. Pay attention to that, people. A single judge is not the court. Because right in the rules, 38 U.S.C. 7253, United States Code, the Court of Appeals for Veterans Claims is composed of at least 3 and not more than 7 judges. A single judge isn't the court. Petitioner is owed the decision of the Court of Veterans Appeals, Court of Appeals Veterans Claims, and a single judge cannot provide extraordinary relief. Now that's what they call a panel or a full court, right? But it's not the court unless there's 3 judges sitting there, or up to 7. You're not before the Court of Appeals for Veterans Claims. Tough judge blathers on. Mr. Ritluski has not demonstrated that he lacks alternative means to obtain his desired relief. That's what he had to say. Well, as proven by the attached letter from the White House addressed to Soldier for Life Ritluski, yes, indeed, petitioner is not a Mr. and rebukes the use of Mr. Ritluski to identify petitioner. Secondly, it is the decision of the court, not a single judge, to determine if petitioner has alternative means. What cannot be denied is that 38 U.S.C. 5706 obligates the Secretary of Veterans Affairs and therefore obligates everyone in the Department of Veterans Affairs to assist the Secretary in upholding his duty to administer all veterans' benefits, and to the shame of the Department, all failed to do so. The judge continues, the veteran can instead petition the agency itself for rulemaking. Okay, well, 38 U.S.C. 7261, which is part of the section of Title 38 that established this Court of Appeals, under scope of review, provides ample jurisdiction for an esquire worthy of wearing a black robe while performing official duties for the United States Court of Appeals for Veterans Claims to provide extraordinary relief required to compel the Secretary to perform. Just write the frickin' order. The judge finishes with 2 paragraphs dedicated to Smoke and Mirrors Forged Veterans ID, available online, that Toth Judge feels petitioners should consider. Good enough. Petitioner admits that Veterans Affairs offers other identifications. However, none require payment of the fee to acquire the identification and therefore are not the 38 U.S.C. 5706 identification, which has been created for the specific purpose of proving the relationship between the Department of Defense and the veteran. It has no equal, and this creation will, among other things, cause corrections in various Privacy Act systems of records containing petitioners' protected personally identifiable information, such as your name, shared by the VA and the DoD. In Privacy Act System of Records, Veterans Affairs / Department of Defense Identity Repository. The Veterans Affairs and the DoD share an identity repository, and it's kept by the VA. That's right, it's maintained by the VA. So petitioner does not accept the substitute. For these reasons, convene the court and issue writs of extraordinary relief. And I went through all this to try to, send it proof of service and try to do all the shit that they make it sound like you have to do. Okay, so obviously all I did is I went to this, back to the order, found the things I didn't agree with, put them on, and away we went. But what I didn't show you yet was, hey, I actually do, right here. On 6/13/2025, the White House sent me a letter, Dear Soldier for Life Ritluski. Now, there's a reason for that, obviously, and if you go to the White House website, they have a contact page where you can contact them, and on that page, it used to have where you had to pick, you were either a doctor, Mr., Mrs., like they only had 4 or 5 choices. And I didn't want, because I don't want to be a Mr., so I just put doctor. And I go down lower on something, put that I was a soldier for life, and explain on a couple of different ones. I did this because I'm not a fucking Mr. I'm not going to use that as my title. Well, lo and behold, I get mail sent to me, Dear Soldier for Life Ritluski. Signed by Donald Trump. There you go. So the Commander-in-Chief says I'm a soldier for life. Somebody's got some explaining to do. All right, so that put us back here. Had the order, I put in the motion, showed that the Commander-in-Chief, the Armed Forces, agrees I'm a soldier for life, not a Mr. Well, the next thing that happens, that appearance came in from this Yahoo here, Giles or Gillis or whoever the heck it is. Okay, well, after all those gyrations, he said this, I said that. Next thing, we get this notice of appearance. And the very first thing says, in the. I'm telling you right now, there is no court with the name in the as part of the name. And the first, the thing supposed to go at the top of the page is the name of the court. Sort of like on this package I had here, right? Because I followed what the judge did. It's called the United States Court of Appeals for Veterans Claims. But this zipperhead puts it in the United States Court of Appeals for Veterans Claims. Like he's not there, right? He's just reporting what happened. And he said this Dennis McDonough was the Secretary of Veterans Affairs. Well, he isn't. It's Doug Collins. And then went on with, please enter my appearance in this matter on behalf of the Secretary of Veterans Affairs. I am the representative of record and will accept service for the Secretary. I'm admitted to practice before the court. I'm going to show you in just a second. Lie, lie, lie. Those are all lies. But the one thing I do think is true is how they did their certificate of service. Right? I called it proof of service, but really it's a certificate of service because you have to certify that you did this. I hereby certify under penalty of perjury that on this date, July 2nd, a copy of the foregoing was mailed, postage prepaid to, and then who it goes to. So that's the proper certificate of service. You don't have to get the return card and do the certified mail. You don't have to do that shit. You need to certify that you served them. So, anyways, just a little detail. So, anyways, I did this a few days ago now, right on the 3rd. And then yesterday and earlier today, I was doing some more research. So I'm going to share some other things after I read this into the record that I found about this particular thing, about an appearance by an attorney into this court. So here we go. This was my protest then. Protest appearance of Gillis S. Sadek. Petitioner believes the individual who filed the notice of appearance requesting entry of appearance as Gillis S. Sadek, allegedly on behalf of Secretary of Veterans Affairs, claiming, I am the representative of record and will accept service for the Secretary, and I am admitted to practice before the court, is in fact in criminal contempt of court of this court. First Court Rule 25C2 states that the Secretary's representative is the General Counsel of the Department of Veterans Affairs. Mr. Richard A. Sauber was sworn in as General Counsel on May 3rd, 2021, and still holds the office. Gillis S. Sadek is not General Counsel. Second, Gillis S. Sadek cannot be the full legal name of any attorney at law admitted to the bar of this court, according to the Real ID Act, the 6 CFR Part 37. Initials and nicknames are not allowed in full legal names and not authorized to use to identify an individual under federal law. Gillis S. Sadek is not named on the certificate of good standing of the bar of one of the courts named in Rule 46, 1A, and now in possession of the clerk of the court, compounding the fraud against the United States that this individual is allowed to continue impersonating as a representative for the Secretary of Veterans Affairs. Finally, contemptor Gillis S. Sadek falsely claims Dennis McDonough is the Secretary of Veterans Affairs in July 2025. Rebuke this impostor and deny the appearance. So that's where we are today, right? That's right, tomorrow. Well, I mean Monday will be the first work day back, and we'll see if they take any action or what happens. But so as you saw, just so we can finish this up, that there was a right. So after the fact, they went back and they changed it to Doug A. Collins or Douglas A. Collins, right? That's really the only change I see on this, and they resubmitted it a second time into the court case. Okay, so as you saw, the Esquire said that he's a member of the bar of this court, right? Well, to be that, then he would have had to have filled out this application for admission of an attorney to the bar of the United States Court of Appeals for Veterans Claims, which comes off the website. Title, name, so forth, fill that out, where you're admitted, so forth, and then attach a current certificate of good standing from one of the courts specified in Rule 46A1, the highest court of any state, District of Columbia, United States Territory, or Commonwealth. And then take an oath. All right, so this is all shit that they had to do. This right here is supposed to be in the custody of the clerk of the court. So let's go ask the clerk of the court, well, what name is on their application? Right? Because if they're not using the name on the application, then they're not admitted to the bar. Yeah, so back here in these rules, right, rules for admission of practice, which is under court rules of procedures, rules of admission of practice, there we go. Admission, that's all this is under Rule 3, what they're supposed to have done. Okay, well, how do they do it? How do you get admitted? Well, they have forms for that. And somewhere down here, we're going to have an application for admission for a non-attorney to practice before the court. I wonder if I should fill one of these out. Application for admission of a non-attorney to practice before the court, and then one for the court. I didn't fill one of these out myself. I have to look at that and talk about it in the next video. But they also have this one up here for a notice of appearance. Right? So the form I showed the guy put in is one that he made up. But there's actually this form. So he didn't follow the rules. He's supposed to put this form in. It didn't say to make up a form. It said file a notice of appearance, and they have a form for that. And they have to have all this information on here properly. And so there's all sorts of errors, right? I didn't even bring this one up, but I'm thinking now when I get done with the video, I'll probably send in another addendum to what I put in to say, hey, he didn't do this either. Because he wants to keep saying that I'm going against somebody in their name, but really it's the Secretary of Veterans Affairs who's the appellee, no matter whose name is used. Where they've made it some individual's name using the middle initial, like Douglas A. Collins. So not only didn't they fill out the application, or if they did fill the application out, I'm not saying that this wasn't filled out by our Esquire friend, right? Gillis Sadek. I'm just saying that they're not using the name that's on here, and it won't be the name that's on their certificate that came from the state court, right? That's in the, and it isn't just this court. This is in all the federal courts, right? That if an attorney wants to practice there, he has to become a member of the bar of the court. And he has to provide a copy of a certificate of good standing. And so if we find a thing now where the names don't match, well, that's contempt of court. It's a misconduct. Just because I went to look at it and found it, here's the application for non-attorney practice before the United States Court of Appeals Veterans Claims, which this part all looks kind of the same as the one we looked at. I mean, you don't have to put any school. You don't have any military. I don't know why they put undefined in there. But if you don't have a law school, does it matter what school you went to? Well, you list them all. Provide description of any duties and training. Take an oath. And if you did all this, you would become an officer of this court, right? And an officer of the court. But to do it, a practice fee of $100 must accompany this application. So it would cost me $100 to become an officer of the court. So I guess I'm not quite ready to do it yet. We'll just see if I can get away with what I'm doing the way I'm doing it. But there you are. If you wanted to be a non-attorney practitioner, you could fill this out, give them $100, and if they docket it, well, then you are. Well, okie dokie. That's where we are today. I'm protesting Esquire identity. They didn't properly identify themselves. And they won't let me properly identify myself because I can't get my ID card. That's how I would properly identify myself, is the proper identification. So that's where we are. And when I know more, I'll do another video. So y'all have a good day, and I'll let you know what happens. See ya now.